The Supreme Court has announced its highly anticipated decision on the constitutionality of the federal health care law. I'm Spencer Mazyck, and joining me now from inside the U.S. Supreme Court to discuss this historic ruling is Tom Goldstein. He's a partner at Goldstein & Russell and the founder of SCOTUSblog, a website that tracks the Supreme Court. Tom has also argued over 20 cases before the court. Welcome, Tom. Thank you for joining us today.
Oh, thanks so much for having me.
So, Tom, the news of the morning is exactly what you predicted. The Supreme Court upholding the insurance mandate, deeming it constitutional. So what does this mean for millions of Americans?
Well, the law that Congress passed is going to go into full force and effect, and that means the individual mandate, the guaranteed for coverage for children, the guaranteed issue, you can't be denied coverage for pre-existing conditions and the like. On the other hand, for people who objected to the statute as a federal overreach and infringement on their individual liberties, they're not going to be happy because the Supreme Court said Congress had this power. It did it for a reason that was a little bit unexpected. But nonetheless, it upheld it.
Tell us about it, because it said the taxing power. Congress has the authority under the taxing power. Can you explain?
Sure. This was a little bit of a surprise because for political reasons, both Congress and the President, at the time the statute was enacted, said we are not enacting a tax here because there's such an anti-tax sentiment in the country. They said this is going to be under Congress's power to regulate interstate commerce. But 5 justices of the Supreme Court said no, this exceeds Congress's commerce power, because what's going on here is Congress is trying to create commerce, force people to buy insurance, rather than regulate commerce. But Chief Justice Roberts provided the critical 5th vote on the government's backup argument, and that is the statute is enforced only in one way, and that is if you don't want to buy insurance, you have to pay a tax. And so a majority of the Supreme Court said this complies with the taxing power of Congress.
So, Tom, tell me this. How is the mandate and the penalty a tax for purposes of constitutionality, but not for the Anti-Injunction Act?
It isn't because it isn't. as happens with Supreme Court jurisprudence sometimes, the justices held that, it's just a different test. The Anti-Injunction Act, as you rightly point out, a statute that says you cannot challenge a tax before it goes into effect, but not this kind of tax. The Supreme Court said, and kind of brushed past that objection, and that's what allowed the Chief Justice, and then joined by 4 other members of the court, to say this is valid under the taxing authority, and we don't see any problem with our deciding that issue today.
So what does it say about the court's definition of commerce since the mandate was found to violate the Commerce Clause?
Well, it's possible this will reinvigorate challenges to statutes as being too broad from the federal government, but I don't think so. The Commerce Clause challenge here was quite narrow. It was that you can't force someone to buy something. And the whole point of the challenge was that there aren't any other statutes like this in American history. And I don't think there were going to be any statutes going forward like it. So I don't think this will really result in a significant restriction of congressional authority. That might not be true of another part of the decision, though, that we haven't yet talked about, and I know we'll get to, and that is the Medicaid expansion.
Yes, I want to get to that in a second, but I want to ask you, do all other components of the law, some of which are already in effect, do they then remain intact?
They do. The way the statute might have fallen apart is that the individual mandate was kind of the the hub around which all the other pieces of the statute rotated. And if the individual mandate fell, that might have taken out other things like community rating, guaranteed issue for people who have pre-existing conditions. But once the individual mandate was upheld, then the rest of the statute stayed too.
Okay, so let's talk about Medicaid expansion. How did the court come down on it?
Well, to set the table just a bit, Congress in the Affordable Care Act substantially expanded both the eligibility requirements for Medicaid, and that is it made it available to lots more people, it told the states they had to make it available to a lot more people, and it also paid most of the freight for that. And what Congress had also said is if the states don't comply with our conditions on taking the money, we can take away this money, and we can take away their old Medicaid money too. And the Supreme Court said that just goes too far. That is too much of a condition. You're essentially extorting the states. Now, I don't think that will affect how the Affordable Care Act operates because no state is going to turn this money down.
Right, exactly.
It would be very, very surprising. It's conceivable, but very unlikely.
So but Congress can't penalize the states then if they decide not to participate.
That's right. By taking away other money, you've put your finger exactly on it. And this principle could apply to other statutes, and that's what's going to be very interesting to watch in later years because Congress all the time tells the states, if you don't do this, we're going to, for example, take away all your highway funding. And this branch of law and branch of states' rights may well have been given a breath of air that could really resonate for years and years and years.
So, Tom, I know that you predicted the outcome today, but weren't you just a little bit surprised by it? I mean, during the oral arguments, there were many who interpreted the line of questioning, specifically from Chief Justice Roberts, as being skeptical of Congress's reach here. So those folks were obviously surprised this morning, but were you?
No, I mean, I had written that it would be decided, and the individual mandate would be upheld, and the other constitutional challenges would be rejected, and it would be an opinion by the Chief Justice. So, I don't think I was surprised, but neither was I overwhelmingly confident for exactly the reason you gave. The administration had the worst of the oral argument. They got given a very hard time, and that's why, the great majority of people went in today expecting the individual mandate to fall.
Well, and I know that the court used legal reasoning to arrive at today's decisioning, and I'm not suggesting that other factors were in play, but do you think Chief Justice Roberts considered just for a minute that a split along party lines would leave the court open to much criticism that the ruling was driven by politics rather than legal reasoning?
Well, he's a smart guy. I'm sure he was aware of it. I don't think it drove what he did, though. He came very close to invalidating the mandate. He said he had this narrow responsibility, which is to uphold the statute if he can find a way. I'm sure he's aware of and pleased with the result, that it's essentially a bipartisan decision. It insulates the court and, by extension, him from criticism for the next 10 years, that it's just a partisan place that's looking for political outcomes. But if he was convinced that the statute was unconstitutional, I don't think he would have hesitated to pull the trigger.
Okay, so let's talk politics for just a minute. As you know, we're smack dab in the middle of a presidential campaign. With the November election 4 months away, what are the political implications stemming from today's decision?
Well, I think for independents and Democrats, this is really good for the president. And so that's, Democrats have to be really pleased about that. They've been taking all kinds of heat about this being an overreach, and the fact that John Roberts in particular wrote the opinion helps them with that. On the other hand, a lot about elections is about getting your base out and getting to the polls, and this will help Republicans in that way. And that is, there are a lot of conservatives and libertarians who are going to be furious about this, who are really going to believe that the statute has to be repealed, that we need a new president and that we need a new Congress, and they're going to show up and vote. So I'm just not enough of an electoral expert to tell you who wins on the net, but everybody has something good politically to take from this.
Does the Supreme Court get the last word here on health care reform with the decision today, or does the fight against Obamacare continue on?
Oh, it continues on. The whole point of the Chief Justice's opinion is we're the last resort, not the first resort. We're only going to strike it down if it's absolutely clearly unconstitutional, but that doesn't mean we think it's the world's greatest law or it should have been enacted or anything like that. If you want to change it, go across the street to the Congress.
So as it stands now, though, the entire healthcare law goes into effect in 2014.
Yes. Well, a lot of it's in effect now, and the mandate goes into effect in 2014.
Well, and I used the term earlier, historic, to describe today's decision. But can you give us a sense of just how significant it really is? In terms of Supreme Court decisions, I mean, what's comparable here?
Well, it's interesting. It would have been an absolutely historic decision, ranking in the top 5 most memorable decisions in American history, if the mandate had been struck down. The fact that the court didn't strike it down means that it's very significant in the moment and very significant for health care. But I don't actually think now that we'll be talking about this decision as a landmark in jurisprudence in 100 years, except in the ironic sense that if the states, by winning their Medicaid argument and limiting the power to extort money, extort compliance from them, really do end up changing the law. So the net long-term historic effect may be, ironically, very pro-states' rights.
Well, any final thoughts, Tom?
No, I'm so grateful you had me on.
Well, thanks so much for being here. I know that you're a very busy man, especially today, so thanks for joining us. We appreciate it.
Thank you.
That's Tom Goldstein of SCOTUSblog and Goldstein & Russell. For more information on this or other topics, subscribe to BloombergLaw.com, and you can follow us on Facebook and Twitter. Thank you for joining us. Bye, everybody.